A federal high court in Lagos has held that the Central Bank of Nigeria can indeed collect and demand for the social media handles of their customers. And this is as part of the standard Know Your Customer procedure, and that this is not a breach to privacy or to the right of privacy of their customers. And one may ask or wonder, can I, understand the legal perspective of this, the legal context and the implications of this? But we do have a legal luminary right now with us. He is Barrister Jubilee Chinonso. Thank you, Barrister, for coming on Business Daily this morning.
Thank you very much. Thank you very much. Nice to be here.
Barrister, I would like for you to, explain the legal reasoning behind, Justice Dimgba's decision, which is to uphold the CBN's regulation requiring the social media handles as part of the Know Your Customer procedure. Can you give us, some perspective into the decision by the court?
All right. First of all, the central bank made this regulation pursuant to the Central Bank Act, which empowers the central bank to regulate commercial banks and their operations. But the case that was before the court, the Federal High Court in Lagos, was rather a case of an individual customer against his bank. And the central bank was saying that customer does not have an account with the central bank. There is no nexus, there is no local standard, and there's no privity of contract. So that case cannot really stand as a proper decider of whether this new regulation by the central bank is legal or not. Because Section 37 of the Constitution of the Federal Republic of Nigeria, I don't know if I'm going beyond your question, but it says that the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. Now, the question is, if the commercial bank has access to my social media handles, which, by the way, I have a right to restrict access to my social media handles. I have a right to create settings that will not allow a person I don't want to see what I post. The reasoning of the court is that social media is in the public domain, but that is incorrect. That is actually an ignorance of fact, because I can create an Instagram account and make it a closed account. So if I don't allow you follow me, you cannot see what I post. I can only in my closed account. So reasoning that whatever I post is already in the public domain and the bank asking for it is not a breach of my right to privacy is incorrect reasoning, and it is a revelation of how little, with great respect, some of our judiciary members, with the greatest respect to them, know about the settings of social media and social media platforms and handles. So I think that regulation is a breach of the right to an individual's privacy, because that regulation will yet be challenged when it is enforced. The court was saying that lawsuit was brought presumptuously. That is, the lawyer could not show that, because it was a lawyer who filed it, could not show that they had already breached his rights. His bank had not said, if you don't bring this thing, you can't operate your account. So they were saying he should have waited. But then there is a problem with that. Section 46 of the Constitution provides that a person can bring a right, a case for the enforcement of his fundamental rights where there is likelihood of the right being breached, not even when the right has been breached already. Where there is a likelihood that the right might be breached, the person can say, I don't want to wait until this thing happens to me. So I want to enforce my right. I want to protect my right. I want to preserve my right from being breached. So that is the situation from my own view. So I think that an appeal of that decision will clarify the issues.
But
an appeal of the decision will clarify the issues.
We have seen the High Court give the CBN the leeway, directing commercial banks to go on with, asking and demanding, in fact, the social media handles of customers. And since that is out there, how then can, we balance between the regulatory requirement and the individual privacy rights in Nigeria?
All right. There is a problem with the Federal Competition and Consumer Protection Act. It lists about 12 rights of the consumer, but unfortunately, there is a lacuna. It does not provide for the privacy of the consumer. So the right to privacy is the general fundamental right that is guaranteed under Section 37 under Chapter 4 of the Constitution of the Federal Republic of Nigeria. However, this right is justiciable. To put it in layman terms, a Nigerian has a right under Section 46 before any high court, either the High Court of the State or the Federal High Court, to enforce the preservation of that right. So this decision by the High Court is only a decision for that case. And in that case, the person who brought the case could not show how that can infringe on his rights.
Oh, interesting.
The court could not have decided what was not before it. So if another person feels infringed, he can head to court. And if he's able to clear his case, the court will definitely restrain the central bank from demanding such things.
But part of that judgment suggested that customers that are unhappy with the requirement could choose not to do business with the bank enforcing it. How might this address, potential customer resistance moving forward?
Well, essentially, I think it is a setback in our advancement in commerce and industry as a nation. Because I feel that knowing your customer is essentially for security reasons and not for invasion of privacy reasons. So I feel that it's going to limit some banks, and that might make some banks not to enforce it if there is an outcry, because there are people who have everything about their lives on the social media, and they don't want their banks knowing what they are doing, the parties they are holding, and the places they are going to. Your bank is your bank, not your family member. So that might stop some people from patronizing certain banks. And what the court said there was actually to still clarify what I said earlier that the court held, that lawsuit, as at the time it was filed, was presumptuous. It is when my bank comes to me and says, counsel, if you don't provide us your social media handles and allow us to be reading everything you post, then you can't maintain this account. Then I will slam them with a lawsuit. Yes, so I already have an account with the bank. The problem is in that case, the lawyer did not even join his bank as a party to the suit. He did not even plead in his whole affidavit evidence, because I think he brought it by originating summons. He did not plead in his whole affidavit setting out the facts in support of the originating summons that his bank has requested any social media handle. So it was speculative, and he does not have an account with Central Bank. Central Bank doesn't bank for individuals. So he just dragged Central Bank to court and then failed to say, okay, my bank has said this. So the banks, when they begin to insist on that, will now trigger the situation where the customers can say, I will go ahead, I will not go ahead. And if all the banks are saying that, then we'll have a class action coming up in Nigeria.
You talked about, customers being uncomfortable with how much they will, share on social media. And what comes to mind is the battle towards curbing corruption and, financial crimes. Do you think the banks now, the commercial banks, having a social media account will, be useful in the area of curbing corruption, even, for instance, now spraying of the Naira note at parties, all of these things that are encouraged on social media?
Well, essentially, it gets back to the same thing. There is a breach of the customer's privacy. That is not in doubt at all, where social media handles are required. I, however, will want to know how this will be enforced, because it's still in the realm of speculation. Are they going to request for my password? Are they going to request to be able to log into my Facebook account and see the messages? Are they going to have a right to look up videos, my memories, and things like that? Well, in that case, that's a very huge breach of the consumer's rights. It's a huge breach of the consumer's rights. I do not have any doubt in my mind that Section 37 of the Constitution of the Federal Republic of Nigeria, as amended, is breached by this regulation. However, I feel that the court in Lagos had a leeway out. They had a window of escape by reason of how that suit was couched. And I am sure that many lawsuits are coming but I feel that the judge should have allowed room for maybe a joinder, but then the court is not a Father Christmas. That is the problem with cases. A case is as good as the lawyer that presents it. The judge is not a Father Christmas. The court could have said, okay, bring in your bank. Okay, let's know what your bank is demanding. Because social media handles the wide thing. I have a WhatsApp. WhatsApp is part of my social media. I have a WhatsApp status. I have a WhatsApp channel. I have an X channel. I have an Instagram channel. So are these things all vulnerable to my bank? Is my bank supposed to be watching me when I'm sleeping and making a live video and doing some personal stuff? So let us know what the limits are. The regulations by the central bank is vague. And that is why that lawsuit should have, first of all, sought a declaration that those regulations be clarified. So if the banks begin to insist on this, and for any reason, any customer feels violated, the person has a right, not only in fundamental rights, because that suit was limited to fundamental rights. The person has a to sue the bank. Yes.
Let us talk about the legal recourse. You've talked about the rights of the customers now towards fighting for in the case where their rights are breached. But looking at the legal recourse now, what exactly can customers do in a case where they believe that rights to privacy have been breached? We seem to have lost our guest there. We were speaking with barrister Jubilee Chinonso about the just recently released judgment of a federal high court in Lagos, where the court has, granted the Central Bank of Nigeria the directive to indeed get the social media handles of their customers. Barrister, now that you're back with us, I was asking you the legal recourse for customers who feel that their privacy has been breached. What ways can they seek redress?
Okay, they can bring a suit, but not for fundamental rights. They can bring a breach of contract suit, because when I was opening the account, I did not have that agreement with the bank. I can bring request for the forms, and I can bring a breach of contract suit. And at that point, I can then join the central bank and seek a declaration of court to set aside that regulation. So the challenge, if I will say it as it is that that lawsuit had a genuine cause but was improperly presented. I'm sorry to say, but that's what the position of the law is. So it's not just a matter of breach of fundamental rights, it's also a matter of breach of contract and tort. So it's the tort of nuisance. The court, the bank, the central bank, and even the court have no legal justification for justifying a person grant.
Again, we seem to have lost our guest, who is barrister.
And I trust Nigerian banks. Oh, it's network. The banks will
go on.
The banks will naturally use that opportunity to begin to determine the relationship with the customer. What about customers that are owing loans? So a person who is owing cannot throw a party. Yeah, it's funny, but it's the truth. No debtor wants his creditor to know that. It's just like when you are a tenant, old folklore, when you are a tenant and then you're cooking chicken. and you're owing rent, and then your landlord can tell that, oh, this man is roasting 5 chickens, and that's like half of his rent, so the bank shouldn't have that much access, but the individuals can still bring their cases. What I said is that one case is judicial precedent for itself, and that is just a decision of the High Court. It has not been tested all the way to the Supreme Court. All right, so nobody should lose heart. The judiciary has not wholly adopted the policies and regulations of the central bank. It is yet to be tested under the fire of appeal and other litigations. Well, so if a customer feels violated, he has every right to head to court.
Let us juxtapose with international practices. Speaking about the ruling of the High Court in Lagos, comparing it with international practices, what exactly is derived or is applicable in Western countries? Do they have cases like this where you are required to divulge such information such as your social media handles, and how has that been in those areas?
Interestingly, by the 5th Amendment, in fact, by the American Constitution,
we seem to be having some network challenges there, but I have
violation of an individual's rights is a total violation of an individual's right to privacy for a bank to insist on that, even by the American Constitution. Even by the American Constitution. So the fact is that our constitutional provision with regards to fundamental rights is an adoption of the African Charter on Human and People's Rights. And this African Charter is a further adoption of the United Nations Convention at Geneva. These conventions are over 100 years old. And it is unknown to law anywhere in the world. I checked up Ghana, I checked up South Africa, I checked up the US, and I checked up our former colonial masters, the United Kingdom. It's unknown to law everywhere in the world that a person will request for a person's social media handle. In fact, in the US, there are constitutional protections for your private mobile number, because over there, their mobile numbers are linked to their bank accounts. So they have restrictions on their private. That is why when you open your phone, the phones are brought from the Western world. So when you open your phone, you have home in terms of phone number. You're trying to save someone's number. There is home, there is office, there is tel, there is this, there is mobile. Your private home address, your private information is not even divulged to your bank. That is why some people are heavily indebted on their credit cards until the bank declares them bankrupt.
Let us talk to you.
So it is strange. Nigeria is being innovative in probably a negative way.
Let us talk about the future outlook, of all of this. One thing you've said repeatedly is that the CBN's regulation is not adopted completely. It's not cast in stone, and there are, there is room for improvement. I should call it that. But what are the future implications, especially from the legal perspective now, as this will impact in the area of, financial institutions and customer relationship with this financial institution? What do you think is the outlook going forward?
All right. Yeah, I envisage a bit of anarchy and chaos. I envisage also that people will become innovative. I think one of the comments that you read this morning from someone who commented on the social media about it, is that people will just create new accounts and give to the banks. And there is no BVN on Facebook. There's nothing like, okay, if I have one Facebook account. In fact, people have Facebook accounts that are not in their names. Now, the problem that also comes with this is it compulsory to have a social media handle? So what happens when I don't have a social media handle, or I deactivated my social media handle or deleted it for privacy reasons? I know persons who have received threats to life from things they put on social media. So they close down all their social media handles for their security. Persons in politics, persons in different fields. So will you insist that I give you a social media handle? That means you are insisting I should create one. No, you now see that that is a breach of many other fundamental rights. It's a breach to my right of freedom of association. I don't want to associate on Facebook. I don't want to associate on X. I don't want to associate on YouTube. You are compelling me to associate with people I don't want to associate with. Because if I have a Facebook account, somebody can see it. I don't want to. So what happens to the person who doesn't want to? So that is why I said I see a lot of anarchy, I see a lot of chaos, but I see a lot of litigation. The banks should get ready with their damages to pay aggrieved customers if they flow with the central bank on this. I believe the first persons in line to object to this should be the commercial banks. They should be the first persons in line. They are the ones with the local standing to even bring a lawsuit and say, Central Bank, we are sorry, but let the courts regulate this. You are the executive, the court is the judiciary. Let them interpret the law, which is the constitution as made by the legislature, and tell us what to do. You seem to be overstepping your bounds because the Central Bank of Nigeria Act 2007 does not make any provision entitling the central bank to make demands from individuals. It only makes provision entitling the central bank to regulate the commercial banks. To regulate the commercial banks. And that is what they seem to be doing. But now they have overstepped, in my own humble opinion, overstepped the bounds of their authority under the law. So what I foresee is a lot of litigation, quite some anarchy, chaos, and then some bit of insecurity. Because in the past, we have had people who were robbed because allegedly someone that had access to banking equipment was able to trace that they had this amount in their account. So they were kidnapped. We've heard a lot of that. We've heard of people's accounts emptied and bank staff being arrested and charged by the EFCC. So now that you are saying the bank will also have access, to my social media handle, if it means the bank will be able to log into my social media account, oh, there's going to be a lot of trouble. So I do not subscribe to that at all.
Barrister,
I do not see where the Nigerian government is heading with that.
Barrister Jubilee Chinonso, who is a commercial litigation lawyer, has, given us the legal reasoning behind, Justice Dimgba's ruling in the Federal High Court in Lagos, actually giving the CBN the right to demand and collect the social media handles of customers as part of its Know Your Customer procedure. Thank you very much, Barrister, for all the insight you've given to us on today's edition of Business Daily.
Thank you very much.
Well, this is where we draw the curtains on today's program. Join the conversation on social media again and let us hear from you. What are your thoughts on this ruling by the Federal High Court? My name is Chiamaka Enendu. Thank you for watching and bye for now.